Come on. Ladies and gentlemen, thank you all for coming to the annual IPLS Symposium. We have a wonderful panel presented for you this year. On behalf of IPLS Executive Board and members, I'd like to welcome Professor Kettle to introduce our panelists.
First, I want to thank the Intellectual Property Law Society for inviting me to moderate the program. One thing I do want to say, though, I had nothing to do with this mugshot that's on here. I am not the star of the show. The star of the show is here, our 7 panelists. It's a great turnout here on both sides. I'm pleased to see that we have representation in all of our areas of intellectual property. Perhaps I'll write publicity, CBS. We can probably talk a little bit about that and ideas, and submission of ideas, and probably deal with that issue too. But I'm going to introduce a panel. Their bio is in the brochure, so I may skip over a few things and move us along. One of these, by way of ground rules. We don't have that much time. I think we have to, what, 10 o'clock tonight?
Yeah.
Okay. Hopefully you have babysitters or other arrangements. But actually, we don't have that much time, so I am going to ask the panel questions. I'm going to pick and choose, although the first question will be for everyone on the panel. And I ask the panel if they can keep their remarks to a couple of minutes, per question, so that we can get to everyone and get to the variety of questions. I did get a number of questions submitted by the board and some students, so pretty much that will save us some time. If we have time at the end, we'll also take questions from the audience, and for those of the panel that can stay afterwards, you'll be able to do a little bit of the meet and greet. Now, for those of you who don't know me, as introduced, I'm John Kettle. I teach some of the intellectual property courses here on the doctrinal side, and on the clinical side, I supervise the intellectual property work that we do in the clinic. What I'm going to do is start down the far end and introduce Mary Beth Schmutz, who is with Rutgers University, the licensing director there. We have, I guess, over 300 licensing agreements in effect.
We do. We have 300 licensing agreements.
Just a few that, of course, Mary Beth has to oversee, covering all areas of use of the Rutgers marks. And they could be for merchandising, obviously in the sporting arena,
Huge, yeah.
that infringement issues, registrations, you oversee the whole portfolio of Rutgers marks. And you would think we would only maybe have half a dozen, but if you go to the USPTO site and just look up what has been registered, and of course there's all the other uses too that have yet to be registered, it's pretty remarkable. Mary Beth has a BA in history from Rutgers and a master's in labor studies from Rutgers. So you're Rutgers red all the way through,
I
right?
really
Scarlet
am.
red.
All about Rutgers.
All about
I've been
Rutgers.
here for 20 years.
Next to Mary Beth is Elizabeth Minot. She's Associate General Counsel at Rutgers in the General Counsel's Office. Oversees research compliance, and intellectual property issues. She received her BA and master's from Harvard in Chinese Studies, which is interesting. So, and of course, our JD from Georgetown Law School. Next to Elizabeth, we have Lisa Catan, who's with CBS, Intellectual Property Counsel there in the Law Department. She oversees a lot, and of course, Lisa will be talking more about the softer IP, copyrights and trademarks, perhaps, again, right of publicity or idea protection. She works in the law department that oversees all of the intellectual property related to all the shows, whether it be entertainment, whether it be sports, whether it be news, a wide variety of that. She received her BS in sports management from Rutgers, another Scarlet Knight there, and her JD was from St. John's Law School. So we welcome you back to Rutgers. in Newark. And apparently you're a Mets and Knicks fan and like belly dancing and fashion and all that other stuff. But in any event, next to Lisa is Kinza Heck, who is a patent agent at Wolf and Sampson here in West Orange. She's involved heavily in the prosecution and also litigation support. I guess the extent that requires your services there as an agent in a variety of areas, mainly in the electrical and computer engineering, but also digital signaling, high definition television area, databases, software technology, television systems, so in a lot of those related fields. And you're also a member of the IPLS, which is the Institute of Electrical and Electronic Engineers. Next to Kinza is David Heck. I imagine there's a relationship there?
Yep.
Yeah, they're married. Okay. So it's not brother and sister, they're married. So. Okay. And David is an associate at Quinn Emanuel, a very well-respected firm, especially on the patent side. And of course, you had a lot to do with the recent Samsung litigation and specialize in the patent area, although you do copyright and trademark litigation as well. I guess on the Apple Samsung, you were part of that lead team, or helped lead that team in that litigation. He holds a law degree from Fordham Law School, but he also brings the scarlet to the table with his bachelor's and master's from Rutgers. And I guess that was an engineering school for your bachelor's and an MBA from Rutgers. Next to David, we have Ruby Hope. And Ruby was, you reminded me, of a former student many years ago. Ruby's a J&J patent attorney who is involved with patent prosecution, patent litigation support. Has done that for a good number of years. I guess focused mostly medical devices and pharmaceuticals.
Medical devices and
Pharmaceuticals, so the transactional work, freedom to operate analysis, etc. Broad experience from the in-house standpoint. And last but not least, our very own Professor Sabrina Safran, who many of you may have taken a course with, or courses. Sabrina is a professor of law here and a Arthur L. Dixon scholar. Prior to coming to the law school, she has a wealth of experience in dealing with and I guess it was the Department of State. You worked with the Bureau of Oceans, International Environment, and Scientific Affairs. I knew some of that, but not all of that that was in the bio. You helped negotiate treaties, international instruments pertaining to biotechnology and diversity and marine pollution. As you can see, Professor Safran's bringing the international side of intellectual property to the table. She got her JD from the Bolt Hall School of Law at the University of California, Berkeley, and her bachelor's magna cum laude from Sonoma College. She clerked for Judge Mary Schroeder, the U.S. Court of Appeals for the Ninth Circuit. You were an associate at a firm out there as well, Hanson and Bridget. So welcome you, of course, but you're always here. And actually, with that, it leads me to the first question now that we've met our panel. I'd like to just spend a couple of minutes, and we'll start. And probably at this one, Professor Safran can hold off to the end, because the question has to do with what's a typical work week like. Although we'd be very interested in knowing what Professor Safran would say, I think most of us probably know. So let's start down the far end with you, then Maribeth.
We do have over 300 trademark license agreements at Rutgers. So that means we, with companies like Nike and Gear and Champion and all the major multinational global brands, all of them. And so in a typical day, mostly is they have to submit artwork to us. Everything you see that says Rutgers on it, we've seen it. I see it first. I see it before it goes into production. So that's maybe 5 or 6 times a day. I have to go into a database. We have an outside company, the collegiate licensing company we work with. Our licensees submit artwork to them, but that's only a small part of it. I might be hearing a lot from our smaller vendors every single day who have trademark issues and what can we do and what can we not do. And that's a big deal. We have lots of, almost on a daily basis, and you know this, we either get a request for registration from an office at Rutgers. We have Eagleton Institute is about to start working on something with the White House, and they've approached us for more. We have lots of, and almost weekly now, we're dealing with some infringement issue somewhere. And that might, I have to say, I'm not a lawyer, but my office is seriously lawyered up. So I work with counsel's office, I work with outside counsel almost, weekly, and we work with the collegiate licensing companies, attorneys as well. So we also have numerous pending registrations going on right now. That's something that with the USPTO can be really, I'm sorry, I have to go on my rant about the USPTO. Really drive me crazy. And so that's something that we deal with almost, really weekly. So, and we also in my office deal with overseas labor and sourcing issues. So we belong to the Fair Labor Association, we're a member institution, I'm the representative. The Foxconn, you might remember, Foxconn issue with Apple, or the Fair Labor Association. I'm on the board of directors of the Worker Rights Consortium. So that also means that I'm dealing with, and that's related somehow, if you're going to ever work in a university in a licensing department, or more like with Elizabeth, with the licensing department, you're going to have to deal probably with these issues as well. So I also deal a lot with student activists, very frequently. They like to just sort of march into my office, and they're fantastic, we like them a lot, but that's a very, we recently, I'll tell you, terminated Adidas's license agreement for no cause, which is a little risky. There's a big labor issue going on with Adidas right now. Wisconsin's suing them.
Actually, the real risk is that we clearly
Right.
did it for cause, but
Right.
said it was for no cause.
And, but we made it clear we did it for, afterwards we did actually send a letter to the students from the president saying why we did it. So we don't know, there's a big lawsuit going on with Wisconsin. So that's a big part of the university licensing world right now. That if you, get involved with that, you will need to know about. So.
Thank you. Liz?
There is no typical week for an in-house counsel, at least at a university, and I'm sure it's true in other areas. The way our office works is that we have certain areas of specialization, so certain matters would tend to be referred to me. But anyone at Rutgers can pick up the phone and talk to a lawyer at the OGC. There's no filter. So I will deal, let's see, last week I dealt with the library and a multitude of copyright issues it has, particularly with digitization of works. There was a professor who thought that her equine feed formula had been stolen by corporations, so we're helping her out. Another professor was accused of plagiarism by someone who is certifiable. So but the certifiable people, you don't have to have a good claim to take up a lot of time and money. I help advise on the licensing, particularly I help on deals that have blown up. I advise on sponsored research contracts, which would be when a private entity, usually a corporation, sponsors research in a professor's laboratory. I also deal with the conflict of interest issues that come up when there is, for instance, a spin-off based on Rutgers IP that then licenses back research to the professor's laboratory. It can be done, but there are various regulations that have to be in place. I'm still just working from last week. There was a professor who was terminated because he tried to do a unapproved human subject experiment with a very small infant, and was not allowed to do that, and was terminated as a result of trying to do that, and he is now fighting that termination. So I deal with copyright, trademark, patenting, and I deal with copyright from both the perspective of protecting the university's copyright, protecting the faculty members' copyright on occasion, that we don't represent individual faculty members, but also giving a lot of advice. I used to go around to give little talks on copyright, and you would be amazed, well, perhaps you wouldn't be amazed, but I was amazed at how few faculty actually understood copyright law at all. I was told by the chair of a department that it was fine for him to Xerox entire books and provide them to his students because he was charging them for the Xeroxing process. They also, the other thing, is people don't understand plagiarism, and they don't understand the difference between copyright and plagiarism. So that was 1 week worth.
Okay, good. Lisa?
Yeah, I guess I can piggyback off Elizabeth's comments. I also work in-house, and rarely a typical week, which is one of the reasons I really like working in-house. You know, juxtaposed against working in a law firm where you have, you know, various different clients. I have one very large client, and I work for, you know, CBS Corporation, which is the parent organization of a lot of different media companies. You know, we have a films arm. We obviously have a broadcast television network. We have studios that do production in television. We have a significant sports division. CBS is also the parent company of Showtime Networks, which is the subscription-based premium cable provider of content. Also, CBS is the parent organization of Simon & Schuster, which is a publisher based in New York. So I see it all when it comes to copyright, all types of intellectual, where, you know, from text and literature to photographs to video content to audio content to audiovisual. And, you know, a typical day really is fielding requests from all areas within the organization, because they all get funneled through I work in the intellectual property section of the corporate law department, and all anti-piracy or content protection matters get funneled through us, and we service the entire corporation. So a typical day involves fielding those requests, which can come from, you know, employees within the organization, producers, talent, their agents or their attorneys, really anywhere, from fans even. And I'll handle those requests, and I'll investigate, and then, you know, I'll, you know, handle the anti-piracy work for that. A large part of my job revolves around organizing and coordinating with automated vendors, which is like a new enterprise for us. As the need for, you know, better anti-piracy enterprise evolves, you know, so have these tech companies that have emerged, that their sole business is catering to these large media companies, helping them, you know, combat digital piracy online. So I've had to, you know, I usually oversee every end of that aspect, from negotiating the deals to managing the relationship to, you know, making sure that, you know, our anti-piracy needs are being met by the vendors. And that's pretty much a typical work week for me.
Great, thank you. Kenza?
Hi. So typical work week for me involves all aspects of patent prosecution. Typically, the clients that I deal with are in the field of computer and electrical engineering. So anywhere from Google's a client, we have some telecom clients, various technology, and I've also dealt a little bit with mechanical engineering and mechanical aspects of patents. So anywhere from drafting applications, conducting interviews with the client and discussing what technology coverage that they're interested in, offering advice, responding to all office actions issued by the United States Patent and Trademark Office, the USPTO, conducting examiner interviews. I think that pretty much covers. Yeah, basically any communication from the patent office, I respond to and deal with that, and also offering clients advice on what is important in terms of technology in the future that they might be interested in. So for example, if a client gets coverage and is issued a patent, they might want recommendation on continuing that patent and filing what we call a continuation application, and giving advice on that aspect as well, post-issuance as well.
Great. David?
So, I would say, I've seen a lot. I've started off as a patent agent, and I went from being a patent agent as a student. I worked part-time as an agent, and I went all the way from there to different firms now. So I have a different perspective. I've seen firms where all you're doing is document review. That exists less now than it did in the past. But at Quinn, where I'm at now, it's sort of like a whole new frontier. Not only is every day totally different, but it's also every night could be totally different too, because we have clients, in Korea. Samsung is one of my big clients, and we get requests from all over the world at times throughout the day, and sometimes ridiculous deadlines. Samsung is now the bane of a lot of my associates' existence, because they want memos turned out in less than 10 hours sometimes. They want instant feedback on what to do, and a lot of times they need to present this to upper management, and they have to figure out what their strategy is day to day on different things, from negotiating with Apple to right now there's suits from Ericsson and Interdigital, and there's all kinds of litigations, as you can imagine, one of the biggest electronics manufacturers in the world would experience. So what a typical week is like, typically it is dealing with the litigation at hand. So right now, my big litigation is the second Apple versus Samsung case, which is going to trial in 2014, which is it's going to be similar to the last one, except none of the design patents that were a big part of the last one, with the rounded edges and all that Apple was asserting. So that can consist of, sometimes we're drafting motions, sometimes I'm just analyzing patents, and because I'm on what is known as the FRAND licensing team, I could quickly go over what FRAND is. There's some things called standard essential patents, which are in your cell phone. You have 3G or LTE, and those standards were developed by players like Samsung, Motorola. All the big guys get into a room and discuss these things. But a part of that is that they agreed to license on fair, reasonable, non-discriminatory terms and conditions. Nobody knows what that means. It's never been defined. It will be defined by Judge Robar in Washington for the Apple versus Motorola action that my firm's also a part of. But nobody knows what FRAND is. So we have we have a lot of issues trying to explain to Samsung and trying to explain to the jury or whatever what's going on with these FRAND patents. But so we're constantly we're pioneers in this regard, and we look at German decisions, and there's all kinds of European actions going on. So my practice is actually extended to analyzing European law too. So it's been really sort of a crazy year or two that I've been on this. So a lot of it is research and motion drafting, discovery, responding to discovery requests, drafting discovery requests, talking to the client to see what their strategy is, preparing witnesses. At Quinn, unlike firms I've been at in the past, first years actually have taken depositions. So it's huge. You get a lot of experience very fast, and we sent a fleet of people last year to Korea to take and defend depositions, and it was wild. But it's a lot of good experience, and well, like I said, like everybody else has said, very unpredictable.
Ruby?
So, I can only echo what everyone else has said. At Johnson & Johnson, how the law department is divided up, so I'm a patent attorney within the law department, and as a patent attorney in the law department, I support certain operating companies. So right now, my main focus is on the pharmaceutical side. So I support companies that make the active ingredients for drugs, and then also, because I spent a good portion of my career on the device side, what I also support are companies within the pharmaceutical sector that are looking at, how many of you have heard of this so-called personalized medicine? Essentially, what this is all about is that, a lot of the easy-to-find drugs are off-patent, You know, and it's very, very hard. I mean, like years ago, there were all of these articles that talked about how the pharmaceutical pipelines were really, really small. Well, now what they're finding is that with all of the genetic testing that's out there, that you can go ahead and show that a particular drug will be good for a particular subpopulation. But in order to do that, you have to marry the drug with a test, and you have to get them both approved at the FDA at the same time. Now, when I first started my career, I knew nothing about regulatory law, but the clients that came to me, I have to look at their agreements. I have to look at the interactions that they have with third parties, with universities. So if I think about the things that I did last week, I spent a good deal of time, because we're entering into an agreement with a university, so I spent a good deal of time reviewing that university's patents, and also reviewing patents that are, you know, competitors' patents, to see where the cross is. Because a lot of times, and you'll see this more and more in your career, the space gets narrower and narrower and smaller and smaller. So you could go to someone who's an expert in the field, who everyone recognizes and said, this is the person that, you know, you want to work with. And then you start looking at their patent estate. So you've got your business on one side, who really wants to work with this person, is that they're the best thing, and then you're the patent attorney who ends up looking at the patent estate and saying, well, you know what, that patent estate isn't quite what you think it is, so maybe it's not worth as much. So you have to constantly make assessments. So last week was looking at a whole bunch of university patents, universities that we are in a certain stage of a deal with, that I drafted a couple of years ago, and now we're looking at going further, and the question is, should we go further? Because we may have to do a lot of out-licensing of third-party patents. So the transactional side can get very, very messy and take up a lot of time. Also, there's a lot of client counseling, because I counsel people from bench-level scientists to presidents of companies. They all come with their questions. I have to admit, I answer the questions for the presidents of the companies first. I'll just give that disclaimer. I mean, because really some days my job is like the old game whack-a-mole. It's like the phone will ring, something will come up, and I've either got to whack it down or I've got to sit on top of it just long enough before it explodes so I can do something else. Because there really isn't a period of time. If I wanted to, I could be busy 24/7. And most patent attorneys, I think, have the same thing. And if there's anything that I could add to this, is that one skill that, you juggle things in law school, the juggling act when you get out of law school is a lot more difficult. And so, just keep that in mind as you're looking at places and looking at firms. I mean, one of the things that David said, there are a lot of firms out there that you wouldn't want to work at because they're going to pigeonhole you too much. I like doing a lot of different things, but quite frankly, not everybody's personality type is the same. So you really want to know where you're going and what people do there. That's about it.
I have a question for Professor Safran. Obviously, we have a lot of aspiring IP lawyers out there, right? There are students who want to be someday perhaps up here on the panel. What do you recommend that they do while in law school? What courses perhaps should they take? What should they be concentrating on? What might better their chances that when they graduate, that they would be more likely to be a successful candidate in obtaining a position at any one of these fine institutions or law firms?
I think they should take as many classes from Professor John Kettle.
I owe you for that one. No, don't. It gives me more blue books I have to grade.
I do think it's important to take a broad range of courses, so I would take back a survey course. Certainly, if you want to do patents, you need to do patents. I think patents is good for a number of stuff right now. The clinical experience is very important. It's good to take federal courts because certainly patents is, as well as copyright, it's all federal law. If you're litigating in that area, you will be in federal court. So I would do that. I would recommend taking admin law because patents and trademarks, this is an administrative agency, so it's important to know how an administrative agency works and the law governing first thing of being a good lawyer is to be a good lawyer. So knowing the basic course as well is really important. I mean, everyone's been talking about contracts. That's a very important class. And I think it's good to look for internships and externships. Right now I'm very gung-ho on students trying to get something with the International Trade Commission. We flagged this for the New Jersey Bar at least 5 years ago in our Patent and Pharmaceutical Symposium as a place of real growth and action. And I think we've seen that where companies are choosing, maybe in addition to litigation or as an alternative to litigation, to stopping goods that are protected by intellectual property at the border. And this is, the International Trade Commission has its own obscure rules and its own way of doing things, and I think now is a great time to try to get into that organization as an intern or an extern and try to learn how that organization works. And I think that could give someone a real leg up when they go on the outside, because right now people don't know. People don't know, and once they're in firms, they're not really in a good position to go do an externship or something of the sort. So now's a good time. I think that's where the puck is going. I think the puck is also going more and more international. I think if you want to know where the U.S. patent system is going, look at what's happening in Europe. I think we're becoming increasingly like Europe here. That's been a trend that is in place for quite some time. So I think seeing where things are going internationally, we're going to see increased harmonization over time. Also, Japan has now overtaken the United States as the #1 patent granting country. So again, international issues are quite large. And one final point, since everyone's drawing upon their experience, I'm going to draw upon my practice experience as well. I came to patent law from dealing with it in the international side, being general counsel to the United States on biotechnology matters. And in that capacity, what I saw was that corporations tended to take the position that if they got the patent, the battle was won. That was the win. That was the big win. They got the patent. But then there was an entire web of other laws that affected the ability to market the product, and certainly market the product internationally. And that included things like food and drug law, environmental rules, the broader regulatory environment that technological goods operate in. So it's important to know that as well. The innovation takes place within a broader legal context. So it's good to have an eye on that.
And I want to ask Elizabeth if you could also address that question from your standpoint, looking out at the students here. Any suggestions that you would have, being in the position you're in, that you would recommend that they take by way of preparation?
I have to say, for the kind of work I do, looking at what the other lawyers in my office have done, is that we don't really pay much attention to what you studied in law school. Though certainly if you took a higher ed course, or as one of my colleagues, if you took a higher ed course that the general counsel taught, that can be helpful. But what we look for generally is, I think every attorney in my office had firm experience. And I realize that's probably not good news, because it's hard to get jobs at firms these days, and it may be that our sort of idea about this has to change. But basically, the university, and I think a number of nonprofits, tend to like to see people who had at least 2 or 3 years law firm experience, with the idea that the law firms train you, and you get the sort of idea of what it is to be a lawyer, and then you come and work for a public entity or a nonprofit. The other thing, and I think this is a general general tip for any sort of interview, you need to know about the organization that you're applying to. You need to do a little research, know that you know specifically about them, and you need to have a narrative that makes sense about why you want to end up there. And so the people who are successful in applying for jobs at our office are people who, for instance, know what kind of research Rutgers is engaged in, who know, who have bothered to actually find out a little bit what Rutgers is about, and who have an interest in higher education law that they can explain. Even if they haven't done higher education law at a law firm, which is not very typical. And if you have IP experience, to explain how that would translate. The other thing I would say is just that there's a lot of lawyers at universities who are not actually practicing law. It's a very useful degree for a lot of different kinds of jobs that are not necessarily practicing law. That may not be something you want to do your first job right out of law school, but it is a very versatile degree.
I would just throw in along with that, a lot of licensing directors across the country are lawyers. For instance, I would say Ohio State, their licensing director is a lawyer, has never practiced law, but he's a lawyer, and in effect, he almost does because of all the legal issues that come up in any licensing office, but very frequently they are lawyers, or the licensing office is in counsel's office, the university counsel's office. That's not unusual.
So for the in-house lawyers on the panel, did you work at a firm for a while before you went in-house, or did you go directly in-house?
I did not, but I think my experience was pretty unique. I think I'm the only attorney in our law department who didn't go through a firm. I ended up at CBS. I started in 2008. I was working part-time as an enforcement clerk, and as the need for a more full-time content protection person grew, so did my role. And so naturally, when I graduated and I gained admission to the bar, there was a opportunity there to have a full-time attorney working most exclusively on content protection. But all the other attorneys in my department had at least 2 or 3 years of experience at a law firm, and that's absolutely true. I think I missed out on that critical training that you get in a law firm. How to be a lawyer 101. You'll learn a lot of useful tools in law school, but how to be a lawyer is something you have to learn on the job.
Yeah. One of the things that Professor Safran had mentioned about the importance of these externships or internships, and talking about the difficulty of getting an in-house position at a law school is almost unheard of, although there are exceptions. There are people who have done that. Those who I'm familiar with who have been able to parlay their internship or externship into a full-time job in-house has been more on the music side. The music labels tend to accommodate a candidate like that, but obviously your positions in the corporate environment that you're in, they're going to look for that 3 to 5 years at least prior experience.
Yeah.
And David, in your law firm, is there anything that you would say to the students here as to if they want to apply for a law firm position, because it sounds like the in-house position would be a little more difficult at this point, but the broader law experience, the better it would be. What would you recommend?
So first I want to say what Professor Safran said about the ITC is very accurate. The International Trade Commission is a very, very, very popular venue. We consider that when we have an investigation active, that's a litigation too. We consider it the same as, basically the same as having a district court action. Samsung had the trial in the ITC at the same time as we had, well, basically the same time as we had in the Northern District of California. So it's not unheard of to have simultaneous litigations because the ITC is a tool to basically exclude at the importation level infringing products, and it's very quick. It happens about within a year. It's in Washington, D.C., so that might not be the best for some of you geographically, but it's a great opportunity because, on the law firm end of things, someone who was, intimately familiar with ITC rules is very valuable, so that's helpful. And I'd say at Quinn, just like at a lot of the other firms, it's getting very, very hard. The same way it's very hard to go into public interest jobs, and all jobs are highly coveted now. The firm jobs, it depends on the firm, depends on the ranking. You know, Quinn, for example, is notorious with, they're looking for a specific grade point average, and the only exceptions are experience. I went to Fordham, and even Fordham is considered a lower ranked school for Quinn. They want Harvard, you know, they want Harvard. It's just like that, that show Suits. And they're really very aggressive about getting those kinds of students. But what I find is there's a lot of lateral associates who come over who have the experience they're looking for. In the smartphone wars, they needed tons of people who were electrical and computer and had some experience litigating, or like I had experience litigation and patent prosecution. So to the extent that you could even do some work, and I know that I overheard you talking about the clinical course.
Yes.
Are you guys doing the
Program.
patent prosecution?
Well, we limit our patent work to preliminary searches, opinion letters based on those searches, and assisting the clients with provisional patent application. We don't do the full patent prosecution. We leave that for your firm and Wolf and Saints.
Well, any exposure you get to practical experience is very helpful. And the other course I would mention is antitrust law. Is very closely associated with intellectual property law. Like Apple threw in an antitrust claim against Samsung that we had to fight off. And it's very popular to do that. So I would just say get as much practical experience as you can. You know, grades are important, but at the same time, even if you're not going to, you know, make a big firm your first year out, even if you're just getting the right experience and then you get to where you want later, that's very possible. But it's very important, you know, to get types of unique experiences that not many people have and make yourself stand out.
I should mention while we're talking about internships, there are internships available at the tech transfer office at Rutgers, and we do encourage people to apply. They have them during the year and during the summer, and they're not paid, as are many internships these days, but you would get experience drafting, say, provisional patent application.
And that's been a good experience. We've had students down at your office and also at AJIT, which is a little closer for some of the students for their course program. So it's very important. Question a student had, some students have asked about, again, presenting themselves to a prospective hire. Certainly the experience, you know, that's very, very valuable. But what about law reviews or journals? Should that be something, and in a particular field, is that important? And maybe I asked you that question. Is grades and prior experience the key thing, or what about journal experience?
I think the journal experience is important, not only because because you've gotten on a journal and you've either been, you know, competed in the competition, but because I think that journals teach you a lot about advocating your position in writing. When I went to Rutgers, I went at night, but I was on the Computer and Technology Journal. And even though I didn't have an article published, it really changed my writing because I was really looking at writing with more of a line to advocacy. And just, you know, everybody's talked about courses, but one of the courses I think is really important is to take the appellate advocacy courses that are offered here. Only because in appellate advocacy, you have to both verbally and in writing get your position across. And that the quicker you learn that skill, the better you're going to be going forward. So if I had to switch, you know, throw up my hands between journal or appellate advocacy, if you had I would go appellate advocacy more than journal. I mean, that's just my particular position, because you have to advocate your position every single day, even if you're not in court, because you're always working with other people and you have to advocate your position. So the quicker you get used to doing that, both in writing and orally, the better off you get.
And everybody on the journal has to do proof looking. And when you're a young associate, knowing how to do correct citations and everything is not only will make your brief writing faster, but you'll have partners turn to you and say, well, how do you cite that? And you know, it's also, I like to think of the journals, I was the managing editor of Fordham's IPLJ, and it was very helpful, great for contacts, and I'd say that a lot of those things are sort of the tiebreakers, because if you have two candidates that have similar credentials, except, you know, somebody did something on a journal, I mean, it stands out. So every little bit helps in terms of, you know, a prospective employer looking at you.
And with regard to the journals, obviously, some of you may be on journals and you're still in the process of topics to write about, which makes me think, and I'll start with you down there, Maribeth. What is the trend? Where do you see things going? Because obviously, if they can write about something that's on the forefront, that they can do research and perhaps even create a buzz about it by writing a paper, entering
You know
a
what,
competition.
it's a big, big deal for us. That wasn't that much long ago, but it's huge right now with domain names. And dealing with, if you're looking for a subject that might be a big area that you, two issues. And of course, you know, I work at a university. I have never, you know, these are the issues I know about. But for us, and if you ever wanted to work on trademark issues at a university, and by the way, look at licensing. They're hiring more and more lawyers to be licensing directors a lot now. You need to know domain names are a big issue for us. I'll give you an example. We are the proud owners of quite a number of XXX domain names. We do protective domain name registrations all the time.
CBS does as well.
Eric LeGrand, do you know about Eric LeGrand?
Mhm.
He was the football player who was hurt. I'd say the day he was hurt, somebody grabbed ericlegrand.com. The next day, we started buying up those domain names. We were too late for that. We went back and forth. Now they're asking, we still haven't bought it up. We have a whole bunch of Eric LeGrand domain names. We still haven't bought it up. Rutgers University, we didn't get a federal registration on Rutgers University for many years because it has Rutgers there. Who can take? We're obviously the first users, right? And you know, we have that. We thought we had that wrapped up, but because of the domain name issue, if you have a federal registration, it's much easier to have somebody relinquish the domain name if it's federally registered. But then we found out, and don't even ask me what we went through the USPTO on that. I won't, I promise, go through. They said it was ornamental rather than, that was the big thing last year, that was kind of strange. That what's happening these days with domain names is they are registered under privacy services outside this country. So RutgersUniversity.com, last time I looked, was owned by the privacy services in the Isle of Man. And you have to go through the World Intellectual Property Organization to even find out who that is. If it's in this country, you can subpoena them, you can find out and get it back. But, especially if you have a federal registration. So, now, the minutes that, we just were going through a merger now. We made this huge list of the possible domain names, whether we're gonna use them or not. If they're at all, similar, we grab them. And we have to spend a lot of time and money on that. And the second issue that is a big issue, if you're ever gonna work for a university, our trademark license agreements have codes of conduct attached to them. And workplace labor codes of conduct. And the overseas sourcing is a big deal. All of our apparel, most of our products are sourced in developing countries. For instance, Bangladesh. There was recently, the rash of fires at factories in Bangladesh. The Tazreen factory where I think it was 171 workers died. Rutgers merchandise, or not Rutgers, but we found one of our licensees, the receipts were found from one of them. That's going to be a big issue for the Adidas, some labor issues overseas. We terminated them. We terminated Russell a few years ago. This is a very big deal. So, and I would think that if you're going to work for any of the big brands, Nike, if you're going to be trademark counsel there, you better know, you really, really are going to need to know about these labor issues and codes of conduct in universities.
Let me ask Lisa, since you deal a lot with that as well, and social media. Where do you see intellectual property in the whole movement, the social media movement?
Yeah, I was just about to bring up social media. I mean, it's a huge new platform for us as well as for some of our opponents. We frequently and on a much more recurring basis are getting requests from, a lot of our talent, authors or actors, sports writers. I went to register my name on Twitter, but someone's already using it. What can I do about that? And a lot of times, we have to counsel these people who have every right to their own name that, well, Twitter's policy has, is very lenient, and they have a very robust, what they call a parity policy. So I can register Craig Carton at Twitter. Craig Carton is one of the sports guys on 660 AM, which is the fan, Sports Radio 66. And he actually had this whole ordeal. He tried to, register his username as Craig Carton on Twitter, and it was already taken by someone who was pretending to be him, but saying, but by the way, I'm not Craig Carton, I'm just making fun of him, using his photo, tweeting as though he was him. And, we were embroiled in a pretty big battle with Twitter, trying to reclaim that username, and Twitter was very adamant that it fit within the confines of its parity policy. So that right of publicity issue is coming up more and more, dealing with social media, because, all of it is brand protection. It's not just registered trademarks, but, identities are becoming brands on social media. So I think that is a huge new environment to be in, especially because Facebook has this enterprise of having pages. And initially what we saw was that we tried to register a CSI page. It was already there. And so trying to reclaim that, ahead of the users who have already had the foresight that we didn't have, has been an uphill battle. And we usually find ourselves like one step behind in doing so. And people are savvy. They find ways, they know the terms, and they find ways around the terms to, continue to exploit our brands and our properties, and not being subject to any sort of punishment by the social media outlets. So, the laws are not that good. They, Facebook and Twitter, as third parties, don't really have an obligation to enforce our intellectual property rights. They just have an obligation to enforce their terms. A lot of times their terms are lenient and broad, and it's within their discretion to determine whether or not it really is a terms of use violation. So I think that area is a really interesting area to be in. Another topic that comes up frequently in my job, at least, is, I'm not sure how many of you have taken copyright law, but the DMCA, the Digital Millennium Copyright Act, is a big part of my role. I think an examination of whether, in 1998, Congress intended the DMCA to work as it does now is a very big question, because the internet in 1998 was a much different landscape than it is, and I think an examination of whether it's still working, or whether we need another law, or whether legislation is the answer, would be a really interesting paper topic.
Okay. And Professor Safran, I guess you get questioned on that from time to time. Do you see any trends, even in the international arena, that would make for a good topic for students?
I think there's going to be a lot of growth in the area of trade secrets.
Sure.
I think this is a real growth area.
And
And also restrictive covenants. Restrictive covenants where companies try to restrict where employees can work. And I think that's a...
And Kendra, as a patent agent, not a patent attorney, are you limited in your capacity as that of your husband here and what he's able to do? Because there were a couple of students wanting to know, what is it that a patent agent can do or can't do?
Certainly. So, in my current position, and I've also been in a few firms, most of the positions that I've done, our group only concentrates on prosecution. So any other patent attorney at my firm, and what they can handle and what they do, I do the same thing. Now, if you're at a place which handles anything beyond prosecution, litigation, any involvement in courts, attending court, going to court, that I don't participate in. But any communication with the U.S. Patent and Trademark Office, I'm able to communicate or show up for an interview. So in that aspect, there's really, it depends on your firm, but at my current position, there's really no difference between what I do and the rest of the patent attorneys do. Yeah.
Ruby, you're in-house,
Yes.
as is Lisa and both Mary Beth and Elizabeth there. How do you find that lifestyle as compared perhaps with David? And David, I see you're outnumbered here. I mean, you know, you're a great guy to be sitting there among all the women. But as you can see, by the way, that the field of intellectual property is not one that I would say has that typical glass ceiling that other positions may have. So it's a good field to be in. But going back, is this a good lifestyle as compared to an in-house position?
Well, you know,
I mean,
as
law
compared to a law firm, I think that we have more predictability in our lives. I think that we don't work as many hours as outside counsel do. I mean, I just don't think that we do that. We work a lot more hours than we used to. You know, when I joined the law department, it was sort of like a 9-to-5 place, because a lot of the work that was there that had to go beyond 9 to 5, everybody had the money and would hire outside counsel to do it. But now, you know, the money is a lot different now. I mean, the times are a lot different, so many things that you could farm outside, you know, many things like when we're doing passive prosecution and we're taking extensions of time, and all of those kinds of things are now really closely watched from a budgetary perspective, much more than they were before, because the corporation doesn't look at the lawyers just as something that we just throw money at. You know, the general counsel has to, you know, the chief patent counsel has to fight for salaries, all of that stuff with other businesses in the corporation, so they want to know what you're doing for them. But quite frankly, I still think that an in-house life is a lot more predictable. Like, I will have really big peaks for a while, but it will slow down. If you're at a firm and you have a really big peak for a while, yet another client comes in, there will not be the chance to slow down. I mean, it's just a different world.
Also, the billable hour is the worst thing
Yeah.
that you'll experience, because you're sort of damned if you do and damned if you don't. So there's some, like Kinza has the problem that she does very low margin, low cost work, being patent prosecution, writing the applications. There's always a budget. So they say, okay, we're not going to pay more than $2,000, I don't know what it is, but $5,000 for a new application or something like that. So if she can't complete the application in that time, she basically has to, somebody's got to write it off. Either she's got to write it off, the partner has to write it off, and from firm to firm, it depends. You don't want to piss the partner off by billing too many hours, so maybe you just suck it up and do it yourself. So that's a concern there. On the litigation end, the hours, the efficiency is less of a concern, but billing more hours is more of a concern, because the big firms make a lot of money off the litigation. So with Apple, Samsung, basically, we were given blanket approval to bill however much it needed, you know, and basically last year I billed well over 3,000 hours, which was a lot, and there were partners who did the same thing. I was at 2 trials. Both of those months, it was like, I mean, I didn't sleep for weeks at a time. I mean, you know, I had like, on a regular basis, I would sleep for a few hours a night, because when you're at trial, it's like being at war. And there are people I worked with who were actually in the Army, and they said, you know what, this is worse, because this is like, at least there you get to sleep. I mean, we had plenty of food, fattened us up, but it's tough, because there's an expectation at the firm that you will always be available, no matter what time it is. Quinn was kind of famous because one of our named partners wrote to some associate who didn't answer him in time, or wrote to the whole firm and said, you know, you should be checking your BlackBerry at the time, it was a few years ago, every hour. And he forgot to mention that, you know, the sleeping hours, but it doesn't exist. And sometimes, you know, I get an email and it'll be 3 o'clock in the morning because it's California time, and sometimes I actually stay up to answer it if it's important enough, or sometimes I'll wake up really early. It totally screws up your schedule, and especially with international clients. But there is an expectation that you will bill lots of hours and you'll always be available, and it's very tough. And it's also very tough on your end because of the efficiency. you know, she has to be, and at firms where that, a lot of firms are, you know, really on a crunch as well because the clients refuse to pay. So you have to be somewhat efficient, and partners, you know, I've been in situations where for smaller clients, you know, the partners will say, listen, you can't spend more than 40 hours on this total, and you just have to do what you have to do. And that's tough.
It looks like you wanted to say something.
My brother, for many years, for his entire life as a lawyer, was an attorney, he just retired. But he was a partner for many years at Morgan, Lewis & Bacchus in Washington, he's a corporate attorney. And I can tell you, he made an awful lot of money. He was quite a wealthy person, but, you know, he has a daughter, his wife is a corporate attorney as well, same firm. And they didn't see their daughter, you know. She was brought up by nannies. He traveled all over the world, you know, but he was not home. He really wasn't. And when he managed to be home, he was so exhausted. And he knew it. He knew that he was making this trade-off. He knew he wanted this very prestigious, you know, a job at this kind of a firm. He wanted to travel, but there was a huge payoff. And when he got to be, you know, middle-aged, trying his age, he was getting tired of it. You know, he said, I don't know about this. It's incredibly rewarding, very prestigious, but there was a trade-off. But then I've known, you know, like you might want to address the difference when you're working for like a Rutgers University.
I was just
Right?
thinking when
You
I.
can have a life. You're not going to make a lot of money. Well, sort of. Well, maybe not you. Especially with the merger going on. But if there is a trade-off like that, you know, Beckman, I remember Beckman Rich was an attorney at Rutgers. He worked for Gucci, and for a lot of years, and he had his son, and he said, I want to bring up my son, so he came to Rutgers so that he could have that kind of a life. So he's not, you know, traveling as much. He's not leaving the office at midnight every day. He's, you know, he was able to leave at a reasonable time and spend time with his son. But he didn't make a lot of money, that's for sure. So
There's definitely a trade-off. I remember when I worked at the firm, the summer that I first summered at the firm, they had I was at Ropes and Gray in Boston, and they had a senior associate come and give us a little pep talk. And I remember so clearly, she said, what I love about this job is every day is like exam period. And I thought, I'm out of here. I'm going to put my 2.5 years, and I'm out of here. I understood what she was talking about. You know, an exam period, you get in the zone, and there is a period, like with luck, right before the exam, where you really think you really know it. Like you've immersed yourself in the material, and it can be kind of thrilling. I can't live at that pitch all the time. She could, she enjoyed it, and she belonged in a firm. I like what I do because I'm a generalist. I don't have to be very specialized. I've developed an expertise. I know a lot about certain things, but I don't. But you can be more of a generalist, at least for my kind of work. And if I really need something and I need an opinion and it's kind of complicated, I call the law firm, and they have an associate who stays up all night and does it for me. And that's very nice. So, you know, I know that, but I will tell you, if you go to an interview for an in-house position and you express that it's a lifestyle choice, you have killed your chance of getting that job. And we've had people who've come in, I mean, it shouldn't need saying, but we've had people who've come in who really want to work for the university, who say that they're leaving a firm because they want a soft landing, who say they do it because they don't want to work as hard, or lifestyle choice. We know, right? I mean, everybody left a firm because they want to have a slightly different lifestyle, but don't say it in the interview. Just, you know, let it be understood.
Okay. One of the things which I had promised the IPLS is that the students would have an opportunity to ask their own questions as well, besides what I had received in advance. So at this point, are there any questions that anyone has out there for the panel? Any questions? So I have a few more here. Questions? Your opportunity. There we go. Correct?
Well, I was going to direct the question to any of the patent people as to what, I guess, industries or technologies or aspects of, you know, scientific developments, what areas are going to be gaining more traction in the coming future, if you could speculate about that.
David, we can start with you.
So I would say, and I would speak somewhat for her too, because we both work for Google in some aspects. So Google, there's right now a race to, there always has been, who can file the most patents, but now there really is a very accelerated race, because you have Apple, who is filing like crazy, and you have Google, Samsung has always filed a lot of patents, but Apple and Samsung are really, Apple and Google are really sort of changing the game, because they're going for a lot of these software patents. Some are online, some are on phone applications or interfaces and things like that. And so there's definitely a lot of prosecution work for these software type companies, and that's been pretty exciting. But at the same time, some of these patents are just horrible. Some of Apple's patents that I've seen are, you guys have probably heard about it in the context of the litigation. They had some of these pinch to zoom and related kind of patents that were just totally, it was a bogus patent. There was tons of prior art out there.
And that's an entirely objective opinion.
Well, you can see the prior art. Look up the Diamond Touch system, and you'll see Mitsubishi had pinch to zoom.
I don't know.
But there's, I would say that's one area, right?
Yeah, I guess I would agree. I've seen personally a lot of business method patent apps. It's just, everyone in the, I guess, startups, they're really interested in covering themselves. So lately, especially, I would say, I've seen a lot of patent applications, and just very little change from, just the technology could be so simple, but just something very simple and very little can potentially get you protection. So, but at the same time, there's still, at least what I see in my field, still a lot of protection and interest in protecting the hardware technology. That's, I think it'll continue that way. And especially internationally, I think it's important to protect hardware also.
Yeah, I don't know if you wanted to, from an international perspective, you see
3D patent, 3D printing.
3D.
So I'm very curious as to what materials are used in 3D printing.
We had a visit here recently from the USPTO, the Director of Office of Enrollment and Discipline, and he had explained about the opening of numerous jobs there, with the focus, however, on electrical and computer sciences, because that seems to be where they're anticipating a lot of the apps, the electrical devices and all. Mechanical, I guess, third in line, but bio and chemical seem to be at the bottom of the list for those who have attended that.
That's another great opportunity. The USPTO is a great starting point, and if you do have any technical degree, if you're willing to relocate to DC, or now they have satellite offices in Detroit, California, I don't know the rest, but Texas maybe. And that's a great job. I know a lot of people who went from engineering school or the other technical disciplines, and they went to the PTO, and the PTO will actually pay for law school. I think they still do. No, they don't. Sorry. Times have changed. But I actually had, when I summered at Jones Day, and there was another summer who was an examiner at the PTO. He turned down Jones Day's offer. He says, I'm already making six figures. He says, I bought a house, and he was really young at the time. He was probably 26, 27, something like that. So I bought a house, and why would I, yeah, it's a lot of money, but why would I give up this lifestyle? I can work from home, because they're very flexible. Their examiners work from home and things like that eventually. So it's a nice career. And the starting salary, even without being an attorney, I think it's like 65 or 70K.
Yeah.
Oh, sorry. I think maybe it's 70 if you're electrical. But it's
You get a
for,
signing bonus.
for a non-lawyer, it's a great salary.
And I'd like to say something about the technology areas, just because when you start practicing in patent law, I was a chemist as an undergraduate. I graduated before molecular biology came on board. I prosecuted electrical engineering, some electrical engineering, a lot of mechanical engineering cases. You can do, and you can shift from area to area, depending on what is out there. Because, once you start learning how to ask people what it is that they're doing, how to find out what the nub of something is, how to, take a stack of art and sort of like look at the trends of where things are going, you really can shift from area to area. And that, quite frankly, has been one thing that, I didn't know in the beginning. I assumed, because I was on the pharmaceutical side when I was, when I was a patent agent and when I was in law school, that I'd stay there and it would be totally pharmaceutical. I had no clue that I would be standing watching production lines, but quite frankly, you can. So it's just, something like, don't think that you have to, if you make a choice, I go into electrical, I'm gonna stay there for my whole career, because you won't.
And a lot of times the firms don't expect, if you're at a firm, firms and companies, they don't expect that you're just gonna be pigeonholed into your discipline that you majored in. Like, I'm working on a case for Merck, and it has to do with a vaccine, and actually, when it comes to the patent, it's a very thin patent, and I kind of understand it. I don't know all the real detail of it, but I could figure it out. The claims are claims, but there's certain patents for me that are much harder. Like, I find chemical and pharmaceutical, because that's not my background at all. But I'm on the litigations, and I know them well enough to, take discovery and do things like that. And we've both done medical devices. So, there's definitely some latitude with what you can cover. And that's partly what I really like about being a patent attorney is you're exposed to a lot of technology. The new stuff, you're not going to have any idea about anyway. So you're constantly learning what's out there and what new technologies are coming up.
Any other questions? Anyone? Who has a question? Oh, yes, Dave?
This question's for Lisa. So you do content protection, things like that. My question is relating to what role does the legal department play in perhaps shifting a paradigm as far as, let's maybe, for instance, now a lot of content providers will put it up on their website with ads rather than just trying to keep it off, torrent sites and things like that, but they're taking both sides of that approach. But how does your role or your department play into that whole scheme of figuring out what's maybe not a legal solution, but a technological solution? How does that work?
That's actually a really interesting question. I think in the recent years, at least speaking from a personal perspective, I've seen the sort of mindset of my company shift from a whack-a-mole to a you can't beat them, join them perspective. And I find, that probably has a longer and more lucrative, fruitful ability to succeed in the long run. I mean, our primary bread and butter is broadcast television, but we're seeing now that the demand is shifting. 24-hour live streaming is the wave of the future, and we want to be one step ahead of the game in terms of delivering the content in legitimate means. So yeah, we're definitely involved in those conversations. And from our perspective, we don't want to be combative. We want to be more collaborative. So to the extent that content is already available online, when we're framing, a cease and desist, maybe we don't frame it as a cease and desist. Maybe we frame it as a, hey, we also have this online. Embed it, use our content. We're asking you to use authorized means of accessing our content. And we're doing that more and more frequently because more of our stuff is being put online. We have an extensive deal with Netflix, iTunes, Amazon. All of that is paid through subscription, but we do put a significant portion of our content online, both current and library. And we're always, we're providing the statistics for, we get a lot of stats back from our vendors, real good raw data that we can analyze and look for trends. We can say, hey, NCIS is really popular in France. Let's license to France. And so we're doing that constantly. We're looking at the trends coming in from from an anti-piracy perspective, because what we're finding is that technologically the pirates always tend to be the most innovative. We're using those trends to present to our business development people, saying, we got a market here, you know, let's use this data to get out there and put our content there, you know, legitimately. So yeah, we're definitely involved in that.
Good question. Any other questions? Yes, Tom?
This is a patent attorney question. Is it good to try to get a job as an examiner out of law school if you want to eventually go on to become a patent attorney at a firm?
Yeah. Yeah, I mean, we have a lot, I mean, in our department, there are a number of people who are former examiners. There are quite a number of people. And quite frankly, that was like one of the routes that people used to go through to get to in-house when it was easier to get to in-house without the law firm experience. So, I mean, you'll find plenty of others there who value that experience.
The one caveat is you might pigeonhole yourself, and this is with a lot of things. I mean, with patent prosecution, there is a stigma associated with it because after so long, after about 3 years or so of doing it at a firm, at the PTO, it would be unusual to go to a firm and then do a lot of litigation, although it's possible. I would say it's more likely if you're at a firm doing prosecution for 3 years, that's like the kiss of death for doing litigation because then you just become too expensive to train. So that's an issue. But a lot of people like prosecution. I mean, I liked it a lot. And even though there are a lot of people on the prosecution end who say, you know, I wish I was litigating, it's so fun, you're going all over the world, it's great. But then at the same time, I'm like, I really wish I had the predictability of, you know, going into my office, knowing my docket, you know, a month in advance of the due dates and just sitting down and doing what I have to do. And that's nice too. So, you know, it's just something to think about.
Okay. Yes?
I think it's a very good thing to do, is to go into patent, to be a patent examiner, or to get yourself into the PTO. Once you're there, you can start looking what else there is to do. Something that is going to be huge, and again, that people don't know a lot about, are all of these supplemental examinations and all of these post-grant proceedings that are going on. So anyone, I mean, you guys are new, so you're going to be able to get in at an early stage. You can get in and start learning the lay of the land on how PTO is analyzing these things, what are the rules. You're going to be great. So if you can do examination for a couple years and then try to move in, maybe work for one of the judges at the PTO, that could be really good. I think it's also important to be intellectually nimble in sort of thinking about how to do things. I mean, don't be like me. I mean, I was really sort of stupid. It was like, oh, what do you want to do? Well, I'm interested in international law. I'll apply to the State Department. I mean, it just happened to work out, but that was like dumb luck. Was not at all being sophisticated. I mean, DOD, Department of Defense, they are a huge user of intellectual property. I would say about trying to get in there, into the general counsel's office. Most people, when they think of DOD or the JAC Corps, they think, well, it's great, I'll get a lot of trial experience. Absolutely true, it is great. But there's also the fact that they have got to have people who are dealing with intellectual property. Because just like these people are saying, oh my gosh, I'm dealing with intellectual property, I'm dealing with intellectual property, their general counsel's office is also dealing with intellectual property, and people aren't thinking of the Department of Defense as a place where you go to deal with intellectual property issues.
And just to, you know, on a personal side, I have a cousin who works for the UN, and this particular cousin is stationed overseas, and when I went to visit them, I met a couple of people who were working at the UN. Just like Rutgers, the UN has an enormous trademark portfolio that they manage, that they license, that they do things with. And quite frankly, the people who are doing that are, you know, they have the traveling overseas because they're stationed somewhere else. And it's just, you know, it was a career that I never really ever even thought about. So there's a lot of different ways you can use your intellectual property background. And so just keep your eyes open for different things that are out there.
I think we also talked a little bit about courses in law school. I think you guys should look at what they're offering at the business school. Just to try to take a course at the business school, because you know what the business school students are? Potential clients.
Yeah, I'd just like to add to that. I think that's really, really good advice. I mean, you know, all of my clients are executives, they're senior vice presidents, and they're marketing people, and they're not used to being talked to in legalese, and to come at them from their point of view, from their bottom line perspective, I think is invaluable when you're talking to clients, you know. That's all they care about. They don't want a memo. They don't want succinct points with citations. They want to know, am I going to win or not? And, you know, is this deal worth doing or not? And they want very succinct bottom line answers. And taking a business-oriented class would help you get that sort of mindset.
They also, they also can have spectacularly bad ideas from a legal point of view. They can have ideas that economically make perfect sense, but violate all kinds of ethical and legal. And it's good to be able to respond to that without saying just flat out no, with trying to make it work.
I was instructed that we should try to end around 7:30, which is about that time, so that you would have the opportunity to get a bite to eat. Oh, it's all gone? Oh, Mike, I'm sorry, I can take that back.
It's fine,
But they also, what we wanted to do is if you have some time, you can stay. Some students may have some individual questions they'd like to ask. So we'd like to you know, invite the students up. But beforehand, let's give them thank you for joining us today and becoming once again part of the Rutgers family. I think everybody up here has some tie
And
to
welcome to the
Rutgers.
profession.
But Karan, you want to?
I just wanted to thank our panelists for a wonderful discussion. We all sure learned a lot more in depth about the possible careers that we might pursue. There's still a little bit of wine left for anybody who's interested, and if it's all right with you, I'm sure a couple of the students would like to ask you a couple of more personal questions. All right, thank you very much one more time.